This is a lecture about the conflicts of interest. This is the first lecture about conflicts of interest that I'm doing about Rule 1.7 for my professional responsibility course. So this is sort of the opening lecture in terms of course content or getting into the course content for my professional responsibility course. We're going to start the course with conflicts of interest. I want to say a couple of things about conflicts of interest and the rules before we go any further, before I start even talking about the language of the rule. First, this is the most heavily tested subject on the MPRE. It's a big subject. We have a whole cluster of rules about this, 1.7, 1.8, which is really like 10 rules packaged into one, and then 1.9, which is conflicts with former clients, 1.10, which is about what to do at a firm if one lawyer has a conflict of interest, and then 111 and 112 are about government lawyers and judges. And so we have this whole like group of rules about conflicts of interest, lots and lots of comments about it. So it's a big subject and it's heavily tested on the MPRE. And so we're going to start with it and we're going to beat it to death. I mean, you're going to be so sick of conflicts of interest and wishing we could move on by the time we get done with it. And I also hate to say it, from my view, the end part of it is really kind of boring. So by the time we really are ready to move on from conflicts of interest, I think you'll be ready to move on too. Now, we're doing this not only for your testing purposes because it's so heavily tested on the MPRE, but there's two other things that I want you to be aware of. Number one, it's also probably the rule out of all the model rules with the most ambiguity in the rule, like requiring judgment calls on the lawyer that in hindsight are going to look wrong. But at the time, when you're making the decision, it's pretty easy to justify to yourself, or it's a hard call about what the right thing to do is. Lots and lots of other rules that we're going to study about, like what kind of fees are allowed, you're allowed to charge a client and so forth, are nice and clear-cut, bright line rules. The conflicts of interest rules have a couple of points of real uncertainty. And so in practice, these can be some of the most difficult rules for the kind of brain teaser or moral dilemma rules that you're going to face as a lawyer on a day-to-day basis. And so I'm willing to bet that the vast majority of you watching this video are going to get through your whole legal career, let's say, and never really have a problem with, let's say, advertising, the advertising and solicitation rules. Like you're just going to, in Texas, you have to get your ads pre-approved by the bar before you run them. And if they want it changed, they're just going to tell you what to do differently. And so it's very rare that we see that, and that you're going to have problems with that. You are going to deal with conflicts of interest all the time as a lawyer, and there are arguable points where you're going to feel it can be nerve-wracking about are we erring on the side of caution here. The other thing I want to tell you is if you look at the studies from the consultants hired by the insurance companies. So there's a group of insurance companies that provide most of the legal malpractice insurance policies in this country. So there's a handful of insurers, less than 10, that cover, that are responsible for almost the entire legal malpractice insurance market. And they put out a report every year. They get together as an industry about what they're seeing with claims. And I can tell you year after year after year, most of the malpractice actions against lawyers that actually have to be paid out, not complaints filed. Most of your complaints, to be honest, are going to be about neglecting a client matter or failing to communicate with a client. The vast majority of grievances or complaints to the state bar are just my lawyer doesn't call me back, or my lawyer didn't work on my case. But in terms of malpractice actions where somebody actually has to write a check, that's disproportionately about conflicts of interest. And so it's not about missing deadlines or the statute of limitations or things like that. When a malpractice insurer has to write a check, more than any other violation, by far, it's about conflicts of interest, lawyers with conflicts of interest. And part of that is because of the ambiguity in the rules and the frequency in which conflicts arise. And part of it is how easy it is in a situation of ambiguity to kind of rationalize and listen to the wrong voices in your inside about what you should do in the situation. And not only that, but the insurers who actually have to write the checks when a lawyer commits malpractice say that the biggest, not only are most of the checks about conflicts of interest, but the biggest checks are because of conflicts violations by lawyers. So it's the area with the most that generates the most malpractice verdicts or actions where someone has to make a payout, and the largest ones. So these ones that are millions of dollars, or in some cases tens or hundreds of millions of dollars that firms have to pay out for legal malpractice, those big ones are usually conflicts of interest cases. And so so this is a rule that is really good to kind of immerse yourself in and spend a lot of time mulling over and thinking about as we go through the and learn the rule. Now, here we go with the rule, and in this video, we're just going to present the basics of the rule, and then I'm going to come back and do other videos where we talk about it. So, Rule 1.7 starts with conflicts of interest between current clients. So right now, forget about former clients for just a minute. And I want you to think about the idea that you are representing Greenacre. You've been doing legal work for Greenacre already. You have a representation underway. And a new prospective client walks into your office, and it's Redacre. And what are they talking about? They have an action that's at where the opposing party is going to be Greenacre, whom you happen to be representing. That's what we're talking about with 1.7. Trying to represent two people, two clients at the same time, not successively. That's going to be a different rule. We're also not really usually talking about the conflict between the lawyer, like the lawyer owning stock in a company or something. That can come under 1.7, but a lot of your personal conflicts of interest or vested interests of the lawyer are going to be covered under another rule, 1.8. Here we're talking about client A and client B, who you are both representing both of them right now, or you want to represent both of them right now, are in conflict. And so here's our basic rule. Except as provided in paragraph B, if you watched another video, you know that's going to be the exceptions. A lawyer shall not represent a client if the representation involves a concurrent conflict of interest. Concurrent conflict of interest means representing two clients at the same time who have a conflict. And then a concurrent conflict of interest exists if, one, the representation of one client will be directly adverse to another client, or two, there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, or a former client or a third person, or by a personal interest of the lawyer. Now, we're going to have specific rules about those last few things, but those violations could also implicate or trigger a violation 1.7. But usually we're talking about another client who you're representing right now. Please notice there are two types of concurrent conflicts of interest under 1.7. So I made a little diagram. It's not that pretty, I know, but this is professional responsibility, right? That's and so now, so here's our general prohibition in A. You can see on your screen. You can't, and it's basically just saying you can't represent somebody except for the exceptions, which we're going to get to in a minute, if there's a concurrent conflict of interest. And then we have two types of conflict of interest. And there's one takeaway I want you to get from this video. It's that all of these conflicts of interest under 1.7 fit into kind of two buckets. Like, have it in your mind. There's directly adverse clients and material limitation clients. Material limitation is a fancy way of saying sort of a bias on the part of the lawyer. There's something that's going to influence the lawyer or make us doubt the lawyer's objectivity or something like that, and create perverse incentives for the lawyer, something like that. So the material limitation is, we don't trust you to be objective and disinterested and loyal to the client. Directly adverse is, or sometimes I'm going to call it direct adversity, but I don't mean adversity in the hardship, I mean they're opposing parties, is the other kind, where you're trying to represent both parties, either in a transaction or adverse parties in litigation, somehow at the same time. So keep in mind, and as we go through the many, many comments and scenarios and situations and hypotheticals, it's always good to stop and ask yourself, okay, we've got Greenacre and Redacre right here. All right, is there direct adversity? If so, conflict of interest. Or is there potential for material limitation? If material limitation sounds vague and mushy to you, you're right. It is. There's a lot of gray area or blurry lines around the edges. Now, I want to talk about B and kind of wrap this up, this little mini lecture. Notwithstanding the existence of a concurrent conflict of interest, you could still go ahead and represent both of them under certain circumstances. And so first, and some of these are going to be positive, like check the box, and others are going to be negative. So first, the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. The representation, two, it's not prohibited by law, otherwise prohibited by law. Well, we're going to talk about that in another video, another lecture. Three, this does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal, and for each client gives informed consent confirmed in writing. And so now I want to go back for just a moment to talk about our two types of conflict of interest. We're going to start with the extreme scenario, and that's what I sometimes call the sitcom scenario, like and that's number 3 right here. And this is something I've seen on The Simpsons and Arrested Development and so forth. This is the lawyer who's trying to represent the plaintiff and the defendant in the same case, running back and forth between the two tables, objecting to his own statements, giving closing arguments and opening arguments to the jury on one side, and then saying, don't listen to anything, that last thing you just said. And this is ridiculous, right? So of course we're not going to allow this. So if you have, if you're representing, Greenacre comes in and to you and says, I want you to represent me, I'm suing Redacre, and then Redacre says, I'd like you to represent my side against Greenacre, you obviously don't get to do both. This is laughable. I'm going to call it throughout the course this sitcom scenario, where you are trying to represent two parties in the same litigation, being the plaintiff's lawyer and the defense lawyer at the same time. No can do. And in fact, it doesn't matter if they both consent to that in writing. They both say, we love this guy. We both want him to be our lawyer. We both don't care about the conflict. It's an unwaivable, or what the model rules clumsily call non-consentable conflict. Now, what's a much more typical scenario? Much more typical is you represent Greenacre already, and let's say you are you represent Greenacre in that you are doing his business incorporation, right? So you're helping him set up an LLC or something like that. And while that representation is underway, Redacre comes in to your office, wants to hire you as a lawyer, and they were injured in a slip and fall or a fender bender or some sort of simple personal injury tort case. And you say, well, who did this to you? And they say, oh, Greenacre. Well, now you have a problem, because even though you wouldn't be representing Greenacre, and I'm going to switch away from the slide here for a moment, even though you're not representing Greenacre as a defendant, they're going to tell them to get another lawyer, you are representing them in another matter, right? So you're doing their business incorporation, or helping them adopt a child, or drafting their will, or selling a piece of property, you're doing their real estate closing, something like that for Greenacre already. And now Redacre wants to sue your existing client. That's sort of our classic conflict of interest that 1.7 is talking about. Again, the extreme case is a sitcom scenario where you're trying to run back and forth between the plaintiff's table and the defendant's table in open court. That's a joke. Of course you're not going to be allowed to do that. But the much more realistic everyday situation is you have been doing legal work for Greenacre. Redacre comes in and wants to sue Greenacre, whom you represent on another matter. But Greenacre nonetheless is still your client, and now you're going to be suing your own client over something. And that would be a conflict of interest. That's our classic scenario of our conflict of interest. Um, and now, remember that this is going to kind of span a range here. Let's go back to our slide for just a moment and look at our exceptions to this. Now, we could have an extreme case, right, where you've been doing Greenacre's legal work and Redacre wants to sue them for everything they're worth. And you're going to have to say, I can't do that. I'm already Greenacre's lawyer. And you're going to decline the representation. That's what you're going to do. Now, on the other hand, sometimes this could be something, I want you to imagine a scenario where they've already come in and agreed to settle this. So they got in a little fender bender and they got out of their cars, and Greenacre, your client, has already apologized and said, look, I'm really sorry, I'll pay you for the damage on your car and so forth. And they're coming to you and they're already, they want to sue, but they're also ready to settle the claim. And so sometimes this could happen where they're on the verge of a deal and they just need somebody to kind of work out the details for them, something like that. In that kind of case, if it's a like kind of low stress case, maybe you think you could probably represent them both, because you're not going to actually have, the case isn't going to trial. The two parties are already pretty far along in settlement discussions. It's a low stakes case, and it's reasonable for you to think that you could actually do the legal work for both of them at the same time. And Greenacre likes you. They don't want to go find another lawyer. Redacre would just as soon deal with somebody who knows Greenacre and stuff like that, has already done his legal work and so forth. So that takes us down to number 4. If each of them will agree in writing to have you as their lawyer, even though you have a conflict of interest, you're allowed to do it. It's not an ethical violation. Make sure you understand that. So that would be a consentable conflict. You're not being the plaintiff's lawyer and the defense lawyer in the same case. You're being the plaintiff's lawyer against a defendant whom you happen to represent in an unrelated matter. And normally you would not be allowed to do that. But if for some reason you think you actually could do this because it's not going to require that much legal work or attacking one of the parties or something like that, it's kind of already on the verge of resolution, and both of the clients are willing to have you do it, that would be okay. Let me give another quick scenario. You've already been representing Redacre, doing Redacre's like real estate transactions, and you've already been representing Greenacre on their real estate transactions, and they're both just clients. You do this kind of work, and now they either have a little dispute they want to resolve, they're dissolving an agreement, or they want to modify it could be a transaction, they want to make a contract, or one of them wants to sell a property to the other or something like that. They're both already your clients. You're already both of their lawyers. You have a conflict under 1.7 if they both agree to have you represent them, and they give and it's informed consent. You explain to them the pitfalls of this, which we will talk about later, and they still agree, and they put it in writing. Always check for that in your questions. It has to be in writing. Then you can proceed. And then again, as long as 2 and 3 are the deal breakers, as long as you're not trying to be the plaintiff's lawyer and the defense lawyer at a trial in the same matter. And number 2, there's not some sort of other statute or case law that says you're just never allowed to do this in this situation. That's pretty rare, actually. But it does come up, and we'll talk about the specific examples that the ABA gives, where there's some sort of law that just says a lawyer is never allowed to represent this party and this party at the same time, in which case the representation is prohibited, would be prohibited by law. Okay, so that's our kind of immediate introduction to conflicts of interest, and we will come back and talk more about this in subsequent lectures.